Hey, everybody. Happy Wednesday. Welcome to True Crime Wednesday. I'm your host, Lori Hellis, and I'm a retired criminal lawyer and the author of that there book. Welcome. We have, well, boy, do I have notes. We have a lot of things to talk about. I'm actually going to save the Corey Richens trial for later because we have a lot of other things to talk about. So while we wait and just let everybody join us, I want to remind everybody this is not legal advice, even though I'm a lawyer. And I also want to remind you that if you happen to have a copy of this their book, I would be happy to send you a signed book plate for your book. So just drop me an email and give me your address, and I would be happy to drop one in the mail to you. I also want to let you know that we are in the process of refining and refreshing our online presence. So my IT guy and I are in the process of doing a few things. First of all, we are going to migrate any of the outstanding websites because at one point we had a website for the Lori Vallow book launch called The Good Lori. And then, of course, I have Lori Hellis author page. And then for quite a while, we had the Lori Vallow story, which was where we posted the newsletters. So we're going to put all of those together into one website, lorihellis.com, and we're going to migrate all of the newsletters, past archive, as well as new newsletters, over to Substack. And I will be adding to that collection of newsletters deep dives into legal issues going forward on Substack. So, haven't quite got that all worked out yet. Then, of course, I have been working really hard behind the scenes to get our first episode of the Granny Files out, and I am oh so close. Um, I am really hoping, fingers crossed, that I am going to get the first episode up on Patreon on Friday, by Friday. So I'm trying really hard to hold myself to that deadline. But when it drops, we will announce it all over our socials. You'll hear about it. It'll be announced on our community page for YouTube and and a lot of other places. So the word will get out quickly. I've had a lot of fun with it, but I'm telling you what, the learning curve is steep. I recorded a whole bunch of videos and I pulled them up and it was like, well, I hate this one and I hate that one. I hate this one so much I don't even want to edit it. So I'm still working on it, still re-recording a few things, and still just about finished up with the project so I can show it to you. So I hope by next week I will be able to show you the finished project and I will be able to tell you all about where you can find the Granny Files. So fingers crossed, guys, because it is. It's a lot different when you're recording and editing and doing an intro. And yeah, I've learned all about producing an intro on AI. It has been fun but frustrating because my brain just doesn't latch on to things like it used to when I was 30. So, but I'm going to keep struggling with it, and I'm confident that as we go along, our episodes are going to get better if I can just get the first damn episode launched. So, but we have a ton of things to talk about. Um, the first thing I want to talk about, I'm trying to get better about putting images up when we're talking about stuff. So I am going to add this image. This is Shana Gardner. Shana Gardner. I'm not sure how she pronounces it. And you may remember that she is accused of having arranged for the murder of her ex-husband, Jared Bridegan. Now, he was a Microsoft executive. She is a heiress to a company called Stampin' Up that was founded by her family. And so on February 16th of 2022, I'm trying to make sure that I get the the information about when these crimes happen, when the trials are happening, just being a little bit more, giving you a little bit more information. So the death of her ex-husband, Jared Bridegan, she and her now husband, Mario Fernandez Saldana, are accused of arranging for his murder. Now, you may remember this story. It's really sad. She and Jared Bridegan were divorced. They had children together. Jared Bridegan was remarried and had children with his second wife. He was on his way home from dropping off his children to Shana Gardner, their children, and he had his toddler daughter in the back seat, the young daughter from his second marriage. When a man stepped out in the road, actually, there was a tire in the road. And when he stopped and got out to move it out of the road, a man stepped out of the bushes and shot him. That person was Henry Tenon, Tenon, Tenon. He was a sometime employee of Mario Fernandez. So there was a connection between the two of them. Um, he admitted to firing 4 shots at Jared, including shots that went through the car and just missed the toddler child. I think that little one was about 2 years old at the time. So Henry Tenon, after Shana Gardner and Mario Fernandez Saldana were and Henry Tenon were all arrested, Tenon rolled over on Shana and Fernandez Saldana and admitted that he had been the trigger man. He pled guilty to second-degree murder and agreed to testify against them. But at a hearing late last year where he was present, he said he wanted to withdraw his plea and go to trial. So that all has been up in the air, and that caused some delays in when we were going to get this trial. So, additionally, um, in November of last year, so late last year, the prosecution withdrew their motion seeking the death penalty for both Shana Gardner and Mario Fernandez Saldana. Their next hearing is coming up this week on Friday, on the 6th of March. And their trial date is now set for August 10th of 2026. But we still have not heard whether or not the issue with Henry Tenon has been resolved, because now he is saying he wants to withdraw his plea and he no longer wants to testify against them. So we're not really sure what is going up there on there. But there was some new video that came out. So I wanted to talk a little bit about that. So a recent video came out. This actually dropped on March 2nd, so just a week or so ago. And the information release came out from the law enforcement from the Jacksonville Beach Police. And it was released hour and a half interview that they had with a friend of who knew both Bridegan and Shana Gardner when they were married. And they also released a whole string of text messages between this friend, her name was Kim Jensen, and Shana Gardner. So during the interview, one of the two investigators that was in the room asked Kim Jensen, Do you think Mario had Tenen do this? Is it even a possibility? And she said, I don't see what the benefit would be. And Mario's a very selfish person. Mario doesn't do much that doesn't benefit him. I just don't see where the benefit would be. Then she said, if Mario did this, you would have called one of your sniper buddies and it would be have been quick, easy, and no one would have known the difference, Jensen said. And he, Mario, thinks militaristically. So the state's attorney's office also released some text messages between Shana Gardner and Kim Jensen. In one thread from July of 2016, Kim said, Shana needs a guy. Oh, this actually text exchange was between Kim and another person named Lee. Kim, Shana needs a guy. Kimmy, or Lee, what kind of guy? Kimmy says, the kind that performs permanent disappearing acts on certain people. Kimmy says, know any magicians? Lee, magician. No, that I do not. For stupid? According to the investigators, Gardner and her friends sometimes referred to Bradigan as stupid. And according to the court records, Gardner and Saldana are set to be back in court on March 6th. I told you that. Prosecutors released, he said that Gardner and her friend Kimberly Jensen often used code words like funeral potatoes. That's a very Mormon thing. And I do believe that Shana Gardner's family are LDS. They use code words like funeral potatoes and doing magic to discuss the potential murder for hire. So, as far as we know, they continue to be set for trial in August, and the hearing that is set for Friday, I believe, is to start to deal with the issues with Henry Tenen's plea. So we'll be following that as we go forward. You folks asked me about Lindsay Shiver. She is the mom from the Bahamas who is accused of having recruited a murder for hire with her boyfriend. She was an Alabama beauty queen, married to a former NFL player who's also from a very wealthy family. And they were supposed to be flying back and forth on the family's private jet to the family's private island home. And it turned out that she was spending a little bit of extra time over there with a guy who was a bartender at the local bar. She and he are accused of soliciting another person to help them commit that murder. The plot was uncovered before the attempt was made, because police were investigating the bar where the lover worked for a possible robbery, and they thought it might have been an inside job. So they asked for the telephones of all the people that work there. Now, Bahamian law is different than the US law, and so there are different requirements for warrants and all those sort of things. But they got everybody's phones and they looked through them and they discovered this text exchange between Lindsay Shiver and the potential gunman and the lover, talking about the plot to kill her husband. So that happened in July of 2023. So we are almost 3 years out from that case. Supposedly, it is supposed to go to trial this month, but the Bahamas doesn't necessarily release exact trial dates, so we don't have a definite trial date when that's going to happen this month. We've talked at length about the fact that there is one prison in the Bahamas. It is in Nassau, and it is called Fox Hill. Now, the women's prison seems to be a bit more humane. They live in sort of a large dormitory, and there appears to be running water. But y'all know the Bahamas is tropical. It's not air conditioned, and the men live in some pretty abysmal conditions. They're in cells that are just open to the open air, where all sorts of vermin come in and out. They don't have plumbing, so they're just given a slop bucket, and the food is pretty bad. And in order to get decent food, you have to bribe guards. The Bahamas, like a lot of third-ish world countries, there's a great deal of government and law enforcement corruption, and a lot of that centers around um, having to bribe police officers in order to get anything done or to get decent food. Family members are allowed to bring food into inmates, but what happens often is if you can't afford to bring the food in and bribe the guards, then you live on whatever is served, which is pretty minimal. So it's not a real pleasant place to be. If Lindsay Shiver is convicted, it is going to be it's not going to be Corey Richens' prisons for rich people by any means. It's a very, very rough place. In fact, it consistently ends up on the top 10 uh, prisons in the world for bad conditions. So we will wait, and I will keep refreshing and inquiring, and we'll see how soon that one happens. Um, the next case that I wanted to talk about is Kelsey Fitz Simmons. Kelsey Fitz Simmons is the woman who was accused of um, assault with a deadly weapon after she was being served with a restraining order that from her fiance that included him taking custody of their 4-month-old child. She was a police officer, a local police officer. She was on leave. Initially, she was on maternity leave. She reported that she was having difficulty with postpartum depression, and she was given a longer medical leave. She was treated and had just been approved to go back to work and to get to be able to have her firearms back. She and the boyfriend, fiance, went on a weekend. It was actually their bachelorette week. It was a co-ed bachelorette weekend before their wedding in October. And while she was there, she consumed alcohol. There was an argument that ensued between the two of them. He claimed that she had punched him, and he got a restraining order against her. The restraining order included him taking custody of the baby boy. And when she went upstairs with one of the two police officers showed up at her house to serve the restraining order. Both of them were colleagues, people that she routinely worked with on the force. And when one of them stayed downstairs with um, Kelsey's mother and the fiance, Kelsey went upstairs to pack a bag for the baby. The master bedroom was upstairs in the house in a loft. The police officer who went with her was somebody who knew her, and he claimed that she pulled a gun and pointed it at him. She claims that she pointed the gun at herself, intending to hurt herself. Um, Interestingly, just recently, within the last week, the defense continues to file motions because the officer that was there with her shot her in the chest. She spent 59 days in the hospital recovering from this gunshot wound. She was airlifted from the scene to the hospital. When she was released from, uh, she actually was indicted while she was still in the hospital. When she was released from the hospital, her attorneys filed motions for her to be out on bond, and the judge agreed that she could be out on bond, but only if she wore an ankle monitor and had a scram unit that's like a breathalyzer where she had to breathe into it whenever it went off randomly. And because of her extensive injuries to her chest, because she was shot in the chest, um, she was still unable to do that. They went back to court and asked the court for permission to be relieved from that requirement. And the judge instead revoked her probation or her release and put her back in jail. So she was in jail for a couple more months before she was finally released just before Christmas. But during that entire time, this person who was supposedly loved her and was going to marry her has turned out to be a real jackass. Um, he just continues to show his true colors. He filed motions for support, filed motions. She had to sell the home they lived in, she owned. He wasn't on the property at all. And he filed said she had to sell the house to pay her lawyer's fees. And he filed a lien against the property for child support for the little boy, even though he only has temporary custody of the little boy. 2 days after she was shot, he broke into her home twice, 3 days after she was shot. He broke into the home twice. First, he went in, then the family changed the locks, and then he broke in. Um, the first time he said he was going in to retrieve his own property. The second time he broke in, the defense contends that he went in and he took all of her devices, her computer, her uh, tablet, and he also took a letter that he had written to her talking about what a great mom she was. It's her house. She's on the deed and he isn't. So technically, it's burglary. However, when the defense asked about it, remember, again, we're in Massachusetts. Think Karen Reed here. When the defense asked about it, he says he asked the police if he could go in and they told him it was okay. And he asked for a standby to go in the second time because he was afraid that once when he broke in and the alarm went off, that her family was going to show up. The police didn't show up either time, and the police say that they have declined to charge him. The boyfriend, the defense is saying, sorry, I had to read my own handwriting here. The defense says he was given immunity for testimony, which seems a little weird since he wasn't actually there when the gunshot happened. He was downstairs, but we'll see. But remember, it is Massachusetts. Now, they filed a motion. Yeah, they didn't have body cams. Surprise, surprise. No, they didn't have body cams. Uh, so yeah, that police force in that smaller town said they didn't have body cams. They can't afford them. So you might remember that the defense had filed motions to disqualify this judge who has clearly been very anti-Kelsey, very unsympathetic to her injuries, very unsympathetic to the fact that she was asking for ADA kinds of provisions for things that she had to do. So the judge, what happened was they filed the request to get rid of the judge. The court came along and said, well, we don't need to make that decision because she's been reassigned. So they've reassigned her to a different docket. And now the current judge has been more reasonable. One of the restrictions that she had on her was that anytime that she needed to see or talk to her lawyers in person, she had to give them 2 days notice that she was, the ankle um, monitors, that she had, to give them 2 days notice. So the judge eased those restrictions and said now she only has to give them 2-hour notice. So the really unfortunate part about it is that the baby in this case is now about 10 months old, and she still can't see him. Um, I think they're hoping that this new judge may ease some of those restrictions, but the problem was that even if they had agreed to visitation for her to have visitation with him, she couldn't because there was a no contact order in the criminal case, and that supersedes everything. So I also have been following the custody case, and I'm going to keep following it. Um, she agreed, this was while she was back in jail for the second time, when the judge put her back in because she couldn't blow in the scram unit. So in October, late October, October 28th, she agreed to a temporary custody arrangement with the father having temporary custody because she was in jail. That has continued because she can't have any contact with the baby because of the criminal court's restrictions. But there is a review hearing set for April, and a pretrial conference in May for a trial in the family law matter and the custody matter. Now, the next hearing is a pretrial hearing on March 12th, and her trial is scheduled to begin on March 23rd. So I'm hopeful that March 23rd, her trial will start, and by April, she will have been exonerated and be able to go forward with the family law case, the child custody case. So the grand jury refused to indict her on attempted murder charges, instead indicted her on assault with a deadly weapon. Her contention is that she never pointed the gun at him, that in fact she pointed it at herself. So we will wait to hear about that, but I think she has a good chance of beating that one. So before we get to Corey Richens, some folks had questions about Colin Gray. He is the Georgia father who was just found guilty and responsible for his son committing a school shooting in September of 2024. So in September of 2024, his 15-year-old son went to school, killed 4 people, and injured 9 more in a school shooting. This is the second time that we have seen a case where the state is holding a parent responsible for the actions of their child. Um, of course, we saw the Crumbly case, Jennifer and James Crumbly. And they were both found guilty as well. So in the Gray case, he was accused So there was information as early as 2018 about. Oh, I'm sorry. There was information actually 2 years before, in 2022, that this young man had interest in the 2018 Parkland, Florida shooting, and he was doing research about the shooter, Nicholas Cruz, and he had a lot of interest in that. He also had made they had found evidence that he had trying to I'm trying to dance around this because of YouTube. So he had made certain threats against other students, and he had a lot of interest in the Parkland shooting and Nicholas Cruz. That was Parkland, Florida, at Marjorie Stoneman Douglas High School. In spite of that, in spite of the fact that the FBI and local police had already been out to talk to this family about their son, Colin Gray bought his son an AR-15 5 months before the shooting. And within a few months of the first time that the issue was raised about him potentially having a hit list or having interest in other school shooters, he was gifted an AR-15. So, if this sounds familiar, that's because we had the Crumblies out of Michigan, that we watched that trial very closely. In the Crumbly case, both parents were found guilty and of involuntary manslaughter, I believe. Now, Colin Gray was found guilty of murder, but the Crumblies were found guilty of involuntary manslaughter, and their appeals are continuing to wind through the system. Ethan Crumbly, the actual shooter, all of his appeals have been denied, and he was sentenced to life in prison. But the parents' appeals continue on apace. Appeals tend to move at glacial speed, so I wouldn't expect that we're going to hear a lot about those appeals anytime soon. um, Speaking of appeals, we are still awaiting the opening briefs to be filed in the Delphi case. And it has been, man, you talk about glacial speed. There have been multiple motions to continue, to give them more time, to file the opening briefs, to file so it's going to be a while, but that one is also moving ahead. So Colin Gray, the father, was found guilty. So I think we're going to see more and more of these cases. I still have some real questions about whether or not you can hold responsible your child, an adult, for something that happens that their child does. Even in these cases where these people have given these kids guns. I mean, I still have some questions about the legality constitutionally for that. I guess we're going to learn more about that as the Crumbly case winds its way through Michigan and perhaps the U.S. Supreme Court as well. And I suspect that the Gray case is going to be following right on its heels in terms of appeals and um, we don't really get a clear understanding of new law until it winds its way through the appellate process. And this is definitely a very new area of the law, holding people sort of vicariously responsible for the actions of their children. It's kind of a whole new frontier. So we'll keep watching that. Um, there is another trial coming up in Florida on April 27th for Courtney Clenny. I have to be honest, I don't like this case. It's not one that really sparks a lot of interest for me. Um, I don't know, but I'm going to report that the trial is coming up in Florida, the 27th of April. Courtney Clenny is accused of having murdered Christian Abumseli, her boyfriend. She was a OnlyFans model. He was a Bitcoin investor or speculator or something. So they were both kind of in this sort of shadowy world online. She claims that she killed him. There was a lot of domestic violence. There were all kinds of recordings of domestic violence, uh, elevator camera, I think, and some other recordings. And she claims that he was viciously violent and that she acted in self-defense, that she threw a kitchen knife at him and it lodged in his chest and he died. Anyone who knows anything about uh, physics and physiology has said they don't believe that's possible. So the most interesting thing that happened recently is she was in a pretrial hearing, and it was a pretrial hearing, evidentiary hearing on motions before the trial. And the cameras caught her mugging and sticking her tongue out and blowing kisses to somebody in the gallery. So she seemed as if she couldn't have a care in the world, while her attorney was sitting there writing. And I think her attorney didn't realize what she was doing, because I guarantee if that had been my client, I would have snatched her up by the back of the head and said, "Knock that shit off." But her attorney was sort of concentrating on something in front of her and definitely was not paying much attention to her client, acting the fool in the courtroom. So, like I say, I have to admit that one's not really high on my radar. I just don't love the case. Um, The next case I want to talk about is Luigi Mangione, and there are some interesting issues in this case. Um, so, not very long ago, the court, there's two things going on. There is a federal case, murder case, and there is a state murder case. Now, we've had the conversation before about the fact that you can be charged under both state and federal law, and it is not considered double jeopardy. It is considered that because they are completely different jurisdictions, that they are violations of two different jurisdictions' law, even though they may be identical in the elements of the crime. It's kind of a weird quirk, and it tends to be kind of an esoteric legal argument. It really gets in the weeds. If you all want me to dig into that, I would do it in a newsletter. So let me know, and I can. We have talked about it a few episodes ago. That if you want a really deep dive into the explanation why federal and state aren't double jeopardy, I can do that. So, the federal court ruled that the charges that they had brought the charges that they had brought the death penalty under didn't necessarily apply, and so the court has ruled in the federal case that he's not eligible for the death penalty. Now, he's being tried in New York, and New York doesn't have the death penalty. So he's no longer running the risk of being subject to the death penalty. But at his last hearing, he was complaining very loudly for the press that being charged both by the state and the feds is double jeopardy. So one of the things that they talked about was the fact that in New York, now remember that state and federal law are often slightly different, and states have the right to be more restrictive in their rules and laws, but not less restrictive than the federal government and the Constitution. Okay. So states can give more rights, or states can essentially can give people more rights or better rights, but they can't give them fewer rights that are in the Constitution. So at his hearing, Luigi Manion said it's the same trial twice. 1 + 1 is 2, double jeopardy by any common sense definition. So what initially happened was he was charged by the feds and the state. And the state has said that they hang on here. I got to get this right. Scheduling the state trial first could help Manhattan prosecutors avoid the double jeopardy issues, because under New York law, the district attorney's office would be barred from trying Mangione if the federal trial happens first. So in New York, they've given more rights and said, yes, if there is a federal conviction, it does amount to double jeopardy under New York law. So all along, they have been trying to get the state case tried first because they don't want him to be able to claim double jeopardy if he's convicted federally first. So there has been all of this pushback back and forth about trial dates, and the state judges have been less friendly to continuances than the federal government has. And there have been sort of jockeying back and forth about which trial is going to happen first. Now, ideally, the New York wants the state case to go first so that if the feds case goes second, that's not double jeopardy. Okay. Under New York law, if the feds go first and get a conviction, they're precluded from state charges. So it's important that the state case go first. So the prosecution in the state case has really been pushing. Let me drop back. So why does it matter? Why are we having two different prosecutions? Well, I think that's as clear as it was in the Murdaugh case. Remember, there were state and federal charges on all the bank fraud. The reason why is because we need a belt and suspenders. We want to make sure that he's going to get convicted one way or the other. So having two bites at that apple is ideal, right? So the state says we want our case to go first because if for some reason we don't secure a conviction, we can still hope that the feds can secure a conviction. So they went to this hearing where Mangione had this outburst, and the judge in the federal case had said, initially there was an appeal filed in the federal trial. So right now the federal trial is set for September 8th, jury selection. Opening statements to start on October 13th. Okay. So, but there's an appeal pending, on an interlocutory appeal, an appeal on a pretrial issue. And so everybody's worried about whether or not that's going to delay the federal trial. Frankly, it doesn't matter if the state court case goes first. So the state case, the district attorney went to the judge at this hearing and said, "We want to set a trial by July 1st." And the judge said, "Okay, we'll set a trial for June 8th." Well, Mangione's lawyer, she is, she's got such an interesting name, and Karen Friedman Agnifilo. She also, the Agnifilo firm has been involved with, another really he was involved with P. Diddy, her husband, Agnifilo. So they're a pretty well-known New York firm. So she says the defense will not be ready on June 8th. And the judge's answer was, be ready. So it does appear that the state case, absent any other delays that they can come up with, is going to start on June 8th. That's the New York State trial. And the judge essentially said to his counsel, be ready. So I wouldn't I wouldn't bank on getting any more continuances there. Now, the federal case is still supposed to start in September, but it could be delayed if the interlocutory appeal hasn't been decided by then, because that's a pre-trial ruling. Interlocutory appeals are appeals on pretrial rulings. I do know that one of the things both the state and federal government have been trying to do is to keep out the things that were found in his backpack when he was arrested. And there's sort of there is a search and seizure issue that they're litigating as to whether or not they had the right to seize those things that were in his backpack. Generally, that's called a search incident to arrest, and it generally is allowed and has been in the past. So it's kind of surprising that we're having that conversation. But we'll wait to see whether or not. But I would be very surprised if the trial doesn't happen in June. Now, neither New York nor the feds allow live streaming. So that's going to continue to be problematic. Hi, She opines. An interlocutory appeal, and it is, I always have to write it down. Interlocutory, interlocutory. What that means is that it is an appeal pre-trial. So for the most part, appeals are only taken, the appellate court will only decide an issue after the trial is over. But there are certain instances where, in order for the person to get a fair trial, they have to be able to appeal the lower court's ruling. They happen mostly in evidentiary hearings. So one side says, the defense says, we're filing a motion to keep out this search and all of the things that were discovered from that search as fruit of the poisonous tree. And the prosecution says, no, the search was legal. So the judge rules, no, it was a legal search. It was okay. And the defense then says, before we can have a trial on this issue, because my client's rights could be violated if you've decided this wrong, before we have a trial on this issue, I need to take that decision to a higher court. So that interlocutory appeal would have to be decided before the trial could happen. Otherwise, the trial, the defendant may not be getting due process, and his rights may not have been adequately protected. So that is that's when the defense, usually it's the defense, is able to ask a higher court to check the work of the lower court's decision pre-trial? So, good question. The next case I wanted to just touch on was Stacy Grist. I didn't write down. She is supposed to have a trial sometime in April, but I couldn't find a specific date. This is a case out of Utah. The victim is Matthew Ristelli. Now, we've heard a lot about this case because Kevin Ellis, who was there are several players in this field. Matthew Ristelli was married to Catherine Ristelli. Her mother, Tracy Grist, and her brother, Kevin Ellis, are on trial for the murder of Matthew Ristelli. So, son-in-law, brother-in-law, Matthew Ristelli. Catherine Ristelli pleaded guilty to murder and agreed to testify against her mother and her brother. Kevin Ellis went to trial. He claimed that he had shot Matthew Ristelli or stabbed him actually with a knife in self-defense. Does this sound a little bit like Vallow Daybell? Yeah. And Uncle Al? Yeah. Well, sorry, I just got a text. I wanted to check, make sure that it wasn't somebody texting me. Sometimes my husband texts me if he thinks my sound is bad or any of those things. So I always want to check those. Sometimes Jen texts me. Anyway, so Kevin Ellis sounds a lot like Alex Cox. Kevin Ellis claimed that he killed Matthew Ristelli with a knife in self-defense. There were a lot of suspicious circumstances. Kevin Ellis was found guilty of murder for murdering Matthew Ristelli, in part on the strength of the testimony of his sister, who had been Matthew's wife. So the last remaining defendant is Tracy Grist, who is Catherine and Kevin's mother. And it appears that her trial is set for April, but I couldn't find a specific date, so I'm going to keep looking for that. Sorry, I have a cat howling in the background because once again, I have a Siamese cat who got locked upstairs with me. The other case I wanted to talk about is Aaron Spencer. You remember that Aaron Spencer is the man who, from Arkansas, who chased down a man who had taken his daughter out of her bedroom. He was a man who was out on bond for having SA'd the same child. And he had actually broken into the home and taken the girl. Aaron Spencer reported it to the police, but he had Find My Phone on his on his daughter's phone, and he followed her and her with her phone and the bad guy. They got into a confrontation, and Aaron Spencer killed the abuser. He claims that it was that he was legal to do so under the defense of others doctrine, which is like self-defense, but defense of another. And so this was set for trial. And in fact, Defense Diaries, Bob and Ali Mata were driving down there to attend the trial. And at the last minute, the Supreme Court, they had asked to relieve this judge of his duties as a judge because of bias. They had also asked to live stream the trial, and it had been denied. And so they filed an interlocutory appeal, And the Arkansas Supreme Court indeed said that the judge was biased and needed to be replaced. And they also allowed for live streaming of the trial. So there have been a couple of recent developments. An attorney named Nadia Stagg has been admitted pro hac vice. I didn't get a chance to look her up, but she has been admitted to represent Aaron in the case for the defense. There is a pretrial conference scheduled on the 18th of March at 10 a.m. to set a new trial date because they were virtually on the eve of trial when the ruling came down from the Supreme Court saying that the current judge couldn't hear the trial. So the trial was sort of indefinitely postponed while a new judge was appointed. Judge Ralph Wilson was assigned. Um, and so now there's a judge in place. He has set this hearing for the 18th to get a new trial date set for Aaron. In another part of news about Aaron Spencer, he in the last few months decided to run for sheriff in his county, and in fact has won his primary. So if he's not convicted, he could very well end up being the sheriff, which would be a really interesting development, wouldn't it? What do you think about it? Hang on, I was just making a note. Um, so, with the exception of Corey Richens, I think that is the last case I wanted to talk about, but we're going to switch over to Corey Richens. So, I can't even remember what day we're on, 7, 8 of Corey Richens' trial. We started out, this week has been a lot of technical sorts of witnesses. We heard from the medical examiner, the toxicologist. We heard from the medical examiner's supervisor. We heard from insurance people, and I think we got we got cell phone data. So we've been hearing from a lot of the more technical witnesses. Now, this isn't unusual at all because they started out the trial with Eric Richens' family. There's a couple of reasons they did that. They did it because they wanted them to be able to be in the courtroom after their testimony, and we've seen that before. They want to get them on the stand as soon as they can so that they can then be in the courtroom. But there's another reason. In a trial, you really want to kind of bookend your trial. You want to start with some emotional testimony that starts to bring the jury in, gets their attention. Then you can go into some of the dry stuff because the jury's already emotionally invested in the story. Okay. Um, any any sort of trial school that a lawyer goes to, the first thing they're going to say to you is, you are telling the jury a story. And be sure that your story is engaging and your story hooks people. So typically what the the prosecution is doing when they start out is they're going to put their emotional kind of witnesses on because now they have the jury invested in the story, invested in Eric Richens and his family and these people. Then that gives them sort of some hooks to hang on to all of that more technical and dry sorts of information. Now, I won't particularly say that there was a lot of dry information, but there definitely were things that were more in-depth and more technical than the straight sort of emotional testimony. Then what you want to do is you want to really bookend on the other end a powerful witness so that the jury then starts to remember, oh, that's why all that dry stuff was important, and get re-engaged with the story. So that's kind of what we've gotten. Today we had the estate planner, we had a tax preparer, or that might have been yesterday. We had a couple of business like th- we had a forensic accountant all day yesterday who talked about the moving around of all the money and what Corey was doing and how she was sort of playing this shell game. She was kind of maxed out on the number of loans she could get, and yet she was going out buying this $7 million half-finished mansion. And I mean, it was very, very clear that she was incredibly overextended. Now, the defense had a lot of objections to this, claiming that it was 4043, 403B, 404, 3 and 4 character evidence, that it was prior bad acts. And the state said, no, it really isn't being brought in for the purpose of proving her character. We want to show the motive for the reason why Corey Richens, she thought Eric Richens had to go. Um, and so they did a pretty good job of putting that all together. I will say that their forensic accountant was excellent. She was very easy to follow. She had good demonstratives, some charts, and it was pretty easy to follow, kind of follow the money, really, and see how Corey had gotten herself into this position. I mean, when she started out, she was buying and flipping one house. She had bought 15 houses, and this big half-finished mansion was the 15th house, and it was $7 million unfinished. So we saw a lot of information about that transaction, about the fact that the house needed a great deal of work and that it was being purchased as is, and it was probably going to take several $1 million to get it to the point where it could be flipped. We also saw some text messages that Corey exchanged with her paramour, as they're calling him, and kind of intimating that she thought it was a great property to be able to rent out for events like big weddings, or where people could stay on the property. And she was talking about, we can rent this out as event space for $15,000 a day. So she really felt like it was something that perhaps could be um, eventually be a money-making venture. So, um, the last witness that we had today was Robert Grossman. This was her paramour. And I'm telling you what, if you haven't seen this, it was hard to watch. He was eh, he was destroyed by this experience. He came into the courtroom. The judge asked him to be sworn in, and when the clerk asked him, "Do you swear to tell the truth, the whole truth, nothing but the truth?" And he said, "What do you mean the whole truth?" That was how this started. Now, what it made me wonder was whether or not he had some sort of an agreement with the state. Is there an immunity agreement where he's like, yeah, I don't know. But it was a very strange question. I never have seen it before. I watched a bit of Emily D. Baker. She said the same thing. Never in my life have I seen this. But the judge sent the jury out, then asked him a few questions, kind of explained, and he said, "Yes, I've sworn to tell the truth." So the weird part about it was during that exchange, Corey Richens seemed to be smiling and sort of like almost laughing under her breath, like trying to suppress a laugh. Um, we found out some information about this relationship that we didn't know before. Corey was in North Carolina. She was doing a house flip there. She was looking for uh, people to help work on that house, and she hired him. They got to know one another. They stayed in contact, and eventually started a relationship. He moved from North Carolina to Utah to be with her. He moved into one of the houses that she was flipping. He lived there for free. Um, and she gave him money. She bought him a truck. She actually bought 2 trucks that he said. She bought him a truck. Then she gave that truck to her mother and bought him another truck. Um, he says they became romantic shortly around 2020 when he decided to move. He was asked about the trip to the Caribbean that she had planned for after Eric Richens' death. He said she booked it in December because it was a gift for his birthday, and his birthday was in December. Then they started in on the texts. Now, I will say the state was kind enough not to make this guy read all these texts, but he sat up there on the stand and he would do a batch of a day's long of texts. He would ask him to review them, confirm that they were between he and Corey, and then he would pull each individual text up. And this guy was so broken. I mean, he was leaning over, putting his head down. At one point, he tried to turn his chair around and face the wall, and the judge said, "No, I'm sorry, you have to turn your chair around." I mean, it was so evident that this guy was in so much pain over these text messages, and the exchange of all these romantic text messages. Um, it it It's interesting to remember that Corey Richens wiped her phone, so these text messages were all recovered off his phones, and, it just was really painful to watch. The defense had just started on his, cross, and actually I hadn't finished with it yet when it was time to go live, so I'm not really sure whether they finished with him today or not. But I mean, you couldn't but help but feel really really feel for this guy. Um, all of financial machinations were put into evidence to show Corey's motive. Um, they brought in Eric's estate planner, attorney. She drafted uh, a new will and a trust for him. When Eric found out that Corey had used her power of attorney that he had given her to take out a $250,000 home equity line of credit, on their family home, he was really mad. Um, and so he went to this estate attorney and decided to rework things to protect his children, really, to make sure that Corey, uh, couldn't piss away any money that would have gone to to their children, their boys. And so he set it up so that there was some of the estate that went to Corey, but there also was most the bulk of the estate was in trust for the children. And actually, what he did was he set the entire all of the it's called a pour over trust. It means that all of the assets of the deceased person pour over into a trust. That included the house, all of his vehicles, his business, everything went into this trust. And he made his sister the trustee. That's a little unusual. If you're married, you usually make your spouse a trustee. But in this case, he had a reason for that because Corey had been known to use family assets to fund these risky flips, house flips. And so he wanted all of that in the trust and for someone to be able to be the gatekeeper for what Corey was using money for. So all of that poured into the trust. The house was in his name and he deeded it to the trust. So it was interesting because after Eric Richens died, a deputy called this estate planning attorney and said, "Will you please talk to Corey and explain to her that the house is in the trust and that she does not own this house?" And so the trust attorney had to get on and explain that to Corey and said Corey was livid. She obviously did not know about the estate plan. Now, the defense has claimed that Corey knew about this estate plan. And so it wasn't a shock to her and it wouldn't have been a motive for murder because she already knew that Eric had given control over his estate to somebody else. I think that's balderdash, frankly. I don't think she had any idea. And from the sound of this estate attorney, she said Corey was livid, and it was very clear that she had no idea that she was not going to own the house. So, um, there was also some discussion about some life insurance policies for the business. So the insurance people came and talked about that. What's really odd is so in the case where you are in a partnership sort of business, you you the partners take out what's called key man insurance, key person insurance, I guess these days. And what that means is that if each of you owns half of the business, you take out enough insurance money, enough insurance that if you die, the insurance will pay off you pay for your half of the business. So, um, so the business can continue to operate. So each of them had that through an insurance company. Now, the weird part about it is at some point, Corey Richens logged into Eric's insurance portal and changed the beneficiary on the partner's insurance to her, then changed it back. And it kind of went back and forth a couple of times. I suspect that Corey didn't really understand what she was looking at in the portal and that she accidentally changed herself to the beneficiary on the partner's insurance. I think what she was trying to do was make herself the beneficiary on Eric's $2 million insurance policy. And that would have cut out the partner and completely undermined the whole reason for the insurance. Well, everybody was alerted, and in the meantime, Corey changed everything back to the way it was. So there was never any risk that the business wasn't going to be able to function because Eric's insurance had gone to Corey. So in general, what happens is one partner buys the estate out using the insurance money. But that would have gone, if he had done that, it would have gone into the trust. If he did that, we don't know. But it would have gone into the trust. So, um, we ended today with Robert Grossman, the paramour, which, because of the way trials are usually structured, it makes me think that the prosecution's at the end of their case. Like I say, I didn't get to finish by the time I came on the air, so I'm not sure. I doubt they would have rested late today. They probably, if they are smart, are going to look things over overnight and then perhaps rest in the morning. But the fact that they ended with this really emotional witness makes me think that maybe they're going to rest. So so that is the end of all the things I wanted to talk about. So now let's find out what you want to talk about. I am sure that you have lots of questions. While Jen is pulling up questions, please like and subscribe. Please hit that like button. It helps us out a lot with the algorithm. And we will see moving forward. I just saw a comment say no walk the dog letter. We have not seen the walk the dog letter yet, so that may be what's coming up tomorrow. That's a good point. Thank you, Lisa. You know, I forget when these things kind of run together sometimes. So I'm thinking about what I know from pretrial, what I know from the bond hearing and all of that stuff. So you're right. We have not seen the walk the dog letter, and that may be coming. I I don't. Well, I think it definitely goes to um, the her consciousness of guilt, maybe. But yeah, it'll be interesting to see how the prosecution brings that in. The walk the dog letter and the supposed novel. It's kind of a quagmire because y they're gonna have to get into where the walk the dog letter came from, and the judge has been hesitant to let the jury know that she's been in custody. We had that slip where the police officer asked about, y they were talking about recorded calls, and she said, "You mean the jail calls?" And, oh, that created a whole kerfuffle. So the walk the dog letter is gonna be one of those having to thread the needle to get that information in without going down she was in jail mode. But if the prosecution is gonna use it, it's probably coming up tomorrow. So, good question. I wanted to remind everybody, like, subscribe if you haven't, um, and don't forget to hit the like button, hit the little bell so you get notifications. Um, Not only will you get notifications about when we go live, but you get other notifications too, like when the episode's going to be up on Patreon. So don't forget to do that, or when we post something new on Substack. So you don't forget to do that. So, what else have you got for me, Jen? Oh, what is the walk the dog letter? Holy cow, I guess we need to talk about the walk the dog letter. Thanks, Lisa, for asking. So, while Corey was after she was incarcerated, um, it is very typical for on a no notice basis for guards to come in and search your cell. And they came in and tossed Corey's cell, and they claim that they found this letter in a book that was an LSAT prep book. So the LSAT is the test that you take to be admitted for law school admissions. It's kind of like the SAT for graduate school for law school. Just like grad school, you take the GRE. So for law school, you take the LSAT. So it was an LSAT prep book, like she was studying to take the LSAT. And in it, they found this letter. Now, there also was a manila envelope that had her attorney's name written on it and legal material written across the front of it. She later passed that envelope to her lawyer through the mail slot, and it was a hefty packet of pages. She claims that this letter, walk the dog letter, was um, was in that packet and that she had given it to her attorney. Or no, she claims that before she passed the packet to her attorney, law enforcement took it out of that envelope that was marked legal material. Um, and then later she gave the rest of the envelope to her lawyer. Law enforcement denies that. They deny that they took it out of an envelope that said it was legal material. The letter itself, the words walk the dog are written across the top, and it is a letter that appears to be to her mother, reminding her or telling her how she would like her brother, if called by law enforcement, to testify. She wants her brother to tell law enforcement that Eric routinely went to Mexico and brought back drugs, and that Eric was using drugs other than marijuana gummies. And she sort of wrote this whole, like, almost a script of what she wanted her brother to say. Now, later, she claimed that it was part of a novel that she is working on. Remember, she claims to have written a children's book, although she wrote it with a ghostwriter. A ghostwriter wrote a children's book for her, so she's now an author. So she was writing a novel. So she claims now that the Walk the Dog letter was actually part of her novel, kind of an autobiographical novel about her case. She claims that the novel is true up until her bond hearing because she had been fantasizing about what she would do if if she was given bond. And so she was in her novel, she absconds from bond and goes to Mexico to find the real killers, the people who supplied Eric with the fentanyl. That's in her novel, right? So she is claiming that the Walk the Dog letter is part of her novel. Um, the prosecution, of course, is claiming that she was attempting to tamper with witnesses. Now, they've never charged her with witness tampering because I don't think they can prove that that letter was ever delivered. Now, there were cases where Tor Corey was writing things and holding them up to the camera or to the window where she was, talking to her mother through the glass. So we don't know what was on that letter, which apparently was destroyed. So we don't know if that letter was if the walk the dog letter that they found was a draft of that letter. We don't really have any idea. The prosecution believes that she was trying to influence her brother into telling a story. So um, the defense filed lengthy motions about the validity of this letter and tried to keep it out. The judge did let it in with a couple of redactions. They claimed that it was attorney-client material. We had a whole discussion last time about attorney-client material and what is protected as attorney-client, under privileged under attorney-client and work product. So check that out. Um, it, the judge allowed some pages of the purported novel to come in as well, but they seem to be less relevant, I guess, less persuasive. The walk the dog letter definitely has the possibility of showing consciousness of guilt. You know, if you're trying to get somebody to tell a story to law enforcement, clearly it's because you think they're going to get the real story. So, um, so we'll see what comes up tomorrow. If the walk the dog letter is gonna come in, it's probably gonna come in tomorrow. Um, but I think that the prosecution may be at the point where they decided that they weren't going to offer the walk the dog letter early, that they were gonna hold off and see how the rest of the case came together. If the case came together the way they'd hoped, maybe they feel like they don't really need it. Um, because it because we can't say that it was delivered, um, if the brother is called as a witness for the defense, which is expected, they can't really use it to impeach him because they can't ever say it was delivered, that he got that information. So, it comes in for the value of being able to prove consciousness of guilt, but it doesn't really come in, it isn't really valuable to impeach the brother 'cause, there's no clear evidence that it was received. Hopefully that made sense, that explanation. So, it's possible the prosecution thinks the case is going well enough they don't really need it, um, because it it really goes to her thinking, "I gotta cover up my guilt." So, good question. Sorry, to quote Kathy from Gossip, Rumor, and Innuendo, "I done talked my throat dry." Hi, Tiff. Good to see you here. How bad is it that prosecution hasn't put the drugs in her hands? Well, we've talked before about circumstantial cases. Circumstantial cases are like a chain, and you don't necessarily have to provide every link in that chain as long as the jury can make the connection by jumping over that blank spot. Um, the more missing links there are in the chain, the harder it is for the jury to make to to jump. I often describe it as picture that you have a jigsaw puzzle and you've got several areas in the jigsaw puzzle that appear to have brown pieces. So you start to build out this one brown area. And before you know it, you can see the outline of an ear and the back and a tail. And you start to think, that could be a horse or it could be a dog. So you keep working away. And maybe you put a couple of other pieces in and the picture really starts to come together. Now, you don't need the entire picture finished, that entire piece to be able to figure out whether it's a horse or a dog. You're going to figure that out with some pieces still missing. That's kind of circumstantial evidence. You're going to be able to figure out the shape and whether that's a dog's head or a horse's head pretty easily, even if you don't have the back half of the image. So that's kind of the way circumstantial evidence works. Um, do they have to put the fentanyl in her hands? Now, I'm the first one to say I think they did a shoddy uh, job of the investigation. Um, they interviewed Corey. She said they had drinks before he went to bed. And yet the evidence, the person who was there to collect evidence didn't even go in the kitchen, didn't look in the kitchen sink where the copper cups were from their Moscow mules. And the housekeeper later said she came and dumped the cups out and ran them through the dishwasher. If there was fluid in those cups, it's possible that those cups, and I mean, those cups could have and should have been tested. They weren't. But here we have this is a guy who is not known in any believable way to have ever used anything beyond marijuana gummies. Now, everything we hear is that he liked marijuana gummies and he used them frequently. We have heard that at one point or another in his life, he drank more. But um, we heard no evidence that he ever used hard drugs. We heard no evidence that he ever drank to intoxication. They've presented no evidence at this point to suggest that he was taking fentanyl himself, was voluntarily taking fentanyl. So here we have a guy who's at home, he's in his own bed, and he dies of an overdose of fentanyl. There's nobody else in the house except his children and his wife. The only two alternatives are she gave it to him or he accidentally overdosed. The jury does not check their common sense at the door. They're encouraged in the jury instructions to apply their life experience and their common sense to the facts of the case. So that tells them you need to be able to make those connections, even if that chain isn't complete, even if there's a missing link. If you can make that connection, jump over that missing link and make the connection that puts the whole chain in perspective, you are invited and encouraged to do that because common sense says if I look at that picture, if I can tell, even though I don't have all of the jigsaw pieces, I can tell this is a horse and not a dog, then it's a horse. And I don't need every little bitty piece. I don't need the last little piece of the back leg to be able to tell you that that's not a dog, it's a horse. So circumstantial evidence is still evidence, and we ask juries to draw inferences from the evidence that spans that missing link. So, do they have to put the fentanyl in Corey's hands? No, I don't think so. I think what they have to say is there a more reasonable explanation that the defense is going to be able to raise that raises reasonable doubt? And I don't know if the defense can do that because their theory is he took the fentanyl and it was an accidental overdose. He voluntarily did it and he accidentally overdosed. But there has to be some sort of supporting information that make that theory reliable, okay? In the law, we call it an indicia of reliability, okay? So if you have hearsay and you say the exceptions to hearsay are when we have some other way of proving the reliability of an out-of-court statement. So it has to have some indicia of reliability. Well, that's the case in a circumstantial case as well, is they have been able to put all of this other supporting information that makes it easier for the jury to say, well, if it's A, B, C, and D is missing, E, F, G, I think we can infer D. I think the defense is gonna have a really tough time putting out that same sort of indicia of reliability into their defense arguments, into their defense theory of the case. Because there hasn't been a lot so far that has supported the idea that Eric Richens was a closet drug user and that he was using opiates um, I in an addictive, recreational way, that nobody knew about. So, I mean, and you only have to turn back to Corey Richens, who repeatedly said he's not a drug user. Well, she was right. He wasn't a drug user. So, I think it's going to be really fascinating to see how the defense is going to put that together. I don't, you can't make a case out of nothing. You can't put pieces together that don't exist. So it's going to be interesting to see how she manages to put all that together. And I mean, if they're going to call the brother Robbie, then I think the walk the dog letter maybe comes out. Um, and maybe it comes out as a way to impeach him and to say, wait a minute, your story lines up pretty closely with with this letter. But again, I mean, the big problem with that is there's no definitive proof Robbie ever saw that letter or got that information. I think the prosecution is going to say, well, she held stuff up for her mother to read, and we don't have that, but we can assume that the mother got the message. She did definitely give some interviews to media where she was sort of telling that story. Oh, no, no, no. He was a drug user and he accidentally overdosed. Yeah, so she was telling that story, and oh, he used to hide his drugs in Corey's luggage when they went places, and yeah, she was pretty much telling the story that was in the walk the dog letter. So they may be able to bring that up on rebuttal and say, um, here she is telling the same stories that were in this walk the dog letter. It's clear that that the information was delivered in some fashion. So we'll see what the defense puts up and what the state holds back for rebuttal. So these are all very good questions. Hi, She opines. Has Corey had a psychiatric evaluation? I think her attorneys would have been foolish not to have her evaluated. However, um, unless they are unless they are putting forward a mental health defense or are bringing up her mental health in some way, they don't have to disclose that. If they are not calling a mental health professional to say that Corey has mental health issues, they do not have to disclose any sort of mental health evaluations they may have had done. We saw this with Chad Daybell. I think everybody's certain that Chad had at least one mental health evaluation, but it was never disclosed because it didn't come up at trial. So, um, the way it comes up, first of all, the way it comes up at trial is if there is a claim of a mental health defense. But even if there isn't a claim of mental health defense, for example, in Kelsey Fitz Simmons' case, I'm sure we're going to hear a great deal about uh, about postpartum depression and about her mental state postpartum. In that case, we're going to have to hear from that expert, and we're going to have to see that expert's reports because they're obligated to turn that over. But in the case where they just say, I wonder if my client has any mental health issues that we could piggyback off of or we could use at trial, and the report comes back and there's not really a whole lot they can use, they don't have to disclose that unless they're making some sort of a mental health claim or putting in some sort of mental health related evidence. So, good question. I think most lawyers in these kinds of cases, and certainly in violent crimes, I think most lawyers would suggest that their clients have an evaluation. If for no other reason than maybe it might come up at sentencing. So, hi, Sharon Hutchins. What was the reason for the Richens defense asking for another mistrial today? Ooh, I didn't hear that. Did they ask for a mistrial again today? Hmm. That's a good question, and I don't know, because I hadn't heard that. So I'll have to go back and listen. Like I say, I didn't get all the way to the end before I came on the air, so I will go back and double check. But I hadn't heard that, and I know they asked for the mistrial based the last one based, I think, on the fact that the the officer mentioned jail calls. But the judge denied it and said the curative instruction was enough. So, but I will look that up. Thank you for asking. Oh, hi, Real Happy. Claim that there was a Brady violation. Hmm. Claim that there was something that the state presented that they hadn't turned over? Interesting. Have you formed an opinion about Corey's guilt? You know, I try not to form an opinion. I try to look at the case and say, has the prosecution met their burden? Rather than direct it at the defendant. I kind of direct it at the case. Um, I feel at this point like the prosecution is proving their case. Um, is the defense going to be able to raise some justifiable, reasonable doubt? Don't know. Um, we haven't seen their evidence yet. I think it's possible because of the piece that Tiff asked about, and that's we can't put the fentanyl in Corey's hands. Um, but I think they have made a very good, substantial, circumstantial case. Um, and I think they're certainly right at that break point of I think they're getting to the point where they have made a logical, orderly, circumstantial case, and absent the defense being able to bring in some bombshell evidence that pokes a hole in their case, I think they're getting there. So, good question. Who's the guilty 1, 2, 3? What do you think the motive of her buying more rugs after Eric's death? Hmm. Um, I don't really know. She owns several different houses, so I don't really know whether they were for her home. I don't know whether there was testimony that that Eric. God, I'm trying to be so proper about this for YouTube. When a person dies of a drug overdose, it is often because it causes respiratory issues. And so, like we saw in the Daybell case, there is often bleeding from the lungs and foamy um, discharge from the mouth. It was remarked that there was blood on the sheet and maybe on the rug. I don't know. I mean, I don't know how we saw a few pictures. It's a little hard to tell how the room was decorated. So hard to say if there was a rug at the foot of the bed. I know she pulled him off the bed to give him CPR. So um, at the direction of the 911 operator. So hard to say about her buying more rugs. Was she replacing the rug he died on? Was she putting rugs in houses she was flipping? I don't know if that was really clear. But I mean, I think the jury could surmise that she was replacing the rugs that he died on. Um, I don't know that that has a lot of weight. I think it's a really different situation where you have, um, a case, w where someone, uh, dies by gunshot, the body is moved. Oh, I thought you said I think she meant more drugs. Oh, Sharon, that makes perfect sense, and you're right. She did actually ask Carmen to get drugs after, um, after Eric died, and I didn't know what to make of that. I didn't know whether she was perhaps going to plant them in the house. It didn't happen. They didn't find any other fentanyl. I didn't know for sure what that was all about. Or was it just that she was trying by having Carmen buy drugs one more time after Eric died, was she trying to sort of muddy the waters and say, "Well, see, these people were buying drugs after Eric died, so this couldn't have had anything to do with me," because they were kept doing those transactions after he died. Those were the 2 things I thought about. Perhaps she intended at some point to plant fentanyl in the house, or she was trying to say, "Well, those drug transactions went on after Eric died, so they couldn't have been related to me trying to get drugs for it to give to Eric." So, yeah, that question makes more sense than rugs. Hi, Real Happy. Curious about your opinion of the tone impression of defense team. Hmm. Um, I don't have a problem with the tone of the defense team. I think that they have been doing a a respectable job. This is a difficult case. I do not expect that Corey is the easiest defendant, the easiest client to deal with. I think that there have been times that they have pushed back. And, you know, you have to remember that this is like a marathon and you're you're in the heat of battle. Okay. You have to think on your feet. You so a lawyer who's there doing cross-examination is thinking about the questions they're going to ask, what possible objections they're going to get for those questions, what the rules of evidence are that apply to those questions, what the next witness is going to say, how what this witness says is going to impact the next witness, and all of that you have to do on your feet while you are in the middle of it. It is kind of like rubbing your belly and patting your head at the same time, or juggling and keeping 3 balls in the air. Um, and I it's very stressful, and different people deal with that differently. I don't think either of the attorneys, either of the female attorneys that we've seen do most of the cross-examination, have acted outside what I would think of as normal attorney behavior in court. Yes, they've pushed back a couple of different times. Um, there have been a couple of times that I sort of thought, "Really? You really went down that road? You really did?" But, y I would not say that they were, um I wouldn't say that they were out of line to the point where I would say, "Oh, that's" you know? somebody ought to take you out to the woodshed or somebody ought to talk to the bar about you. Um, Neither one of those things. I think that they're both um, experienced. They're quite prepared. I mean, um, Lewis, the little bitty gal, man, she had those documents out and those binders and, turn to this one, turn to that one. I mean, she knows this case. She knows her evidence. But I mean, I can see how people might have found her to be a bit abrasive. Certainly, the young DA, I think his name is Ramos, he kind of got off on the wrong foot early on in the case and had to sort of dial it back in. So I could see, um, and I remember that this is a case that they've been preparing for a long time. And, opening night jitters are a thing when you first start a case. Once you get into the case, you kind of start to find your rhythm. But the first few hours, you're trying to make sure all the tech works. You're trying to make sure that I will say they have done a really excellent job. Both sides have done a really, really good job with all their tech, with the exhibits coming up and down, and they've done a really good job with that. Both of their tech people have been right on top of stuff. There was at least one instance where they asked their tech person to redact something in real time, and they did it. So that they've done a good job, and they've also done a good job of using their technology. They've done a really good job of getting stuff up and asking questions about it, and that comes from being comfortable with the evidence, and knowing your case. So, I I didn't find their behavior all that objectionable. I do know at one point, um, uh, N Nate, Nader, is that her name? The larger of the 2 women, at one point, somebody pointed out that she kind of rolled her eyes. I don't know. I mean, we cannot always control every movement of our faces. And when you're in that situation and you're not thinking about how this looks, you're thinking about making the connections and trying to figure out this evidence ruling and whether this is going to come in and I mean, you can't fault someone for not remembering to pay attention to this while their brain is going 90 miles an hour. So, I don't know. What do you all think? Um, I mean, I've heard some criticism out there about both of them. Now, I will tell you that compared to what's her name from the Donna Adelson's lawyer, the funeral home owner Jackie Fulford. But compared to her, these guys are miles ahead of her. She was a piece of work. These women know what they're doing. And Nestor, Kathy Nestor, I think that's her name. She has also been appointed to represent um, the defendant in the Charlie Kirk murder. Um, so that one's going to be coming up pretty quickly too. So they both Utah cases. So she's going to finish this and go right into prep for that, I'm sure. I would be surprised if he doesn't push for a early trial. So, what else do you guys think? Tiff Knox. If your child sells drugs at school and another student buys some and dies from it, are the parents accountable? This is a wonderful question. Thank you, Tiff. Because it's that slippery slope, right? So I guess the question would be more likely to make it line up with the Crumblies is if your child finds your drugs, you, the parent, takes them to school and either sells them or gives them to another kid who dies, are you accountable? Because that makes it more like the case where the parents are gifting firearms that the kids are then misusing. So, yeah, if the kid sells drugs at school, you're not involved in how they acquired those drugs, and you're not involved in any way with how they got them, then I think no. But th- to make the case to be more like the Crumbly case is if you are a person who's a drug user, say you're an opiate user and you're using maybe even microdosing fentanyl, and your child gets it and takes it to school and gives it to another kid, are you responsible? That's a bigger question. It's a different thing if you've got a medicine cabinet and you have a prescription that you are prescribed legally and the kid takes it, maybe that's a different shade of gray. But if you are using illicit drugs and your child takes them from you, even if it's unbeknownst, and goes to school and sells them and somebody dies from it, yeah, then I think you have a case that's more analogous to Crumbly and Gray. So, and it makes you wonder. I mean, where does that slippery slope go? Um, are parents responsible for their adult children if they live in their house? So, you have a young adult son who's over the age of 18 but lives in your house. Where do we draw the line? I guess that's the question. And I we don't know yet because Georgia and Michigan are out there making new law. Um, because these are not cases where we have seen states hold parents responsible for the deeds of their children. So yeah, we're out there plowing new ground. Speaking of plowing ground, I didn't talk at all about the Wagner, or not Wagner, Warner case. Sorry, they're all running together tonight, guys. I'm getting tired. Um, the Warner case. The both sides rested, and that's going to go to the jury probably tomorrow. So who knows if we'll have a verdict by Friday. That is Dee Warner, and that is a Michigan case where Dee disappeared. 3 years later, her body was found welded inside an anhydrous ammonia tank. Anhydrous ammonia was part of what they used to make fertilizer to fertilize fields. And Dale and Dee Warner owned a farm along with several other businesses. So she disappeared, and her adult children were sure that Dale was responsible. He was arrested before her body was found, but then they found her body 3 years later. So, and we've all talked about the fact no body cases are much more difficult to prosecute, but they were going to go forward with a no body prosecution at that point. He'd been charged with her murder. So, um, that case has been interesting to see it come together because they they ran a business on this big property where they also had a house. So they had several businesses that ran off this farm property. So there were a lot of people in and out of that property. Um, Dee's kids were involved in her adult children were involved in the operations of the businesses. There were employees around, and so there were a lot of eyes on that property. And it's been surprising to see the number of people who had a little piece of the puzzle here or there. This guy came in to get a truck to go make a delivery, and he saw this, and this person saw that, and yeah, it's been interesting to see the way they have pieced that puzzle together. So, I think the jury's gonna come back with a guilty verdict, and I don't know that it's gonna take a lot of time. There is a lot of, text and, email kind of evidence, so it may take them a while um, to go through all that, so but hmm. Hi, Mac. This one's tough. Um, any thoughts on the Nancy Guthrie case, her whereabouts and a motive? You know, this one is a stumper. It's a head scratcher. Um, of course, the longer she's gone, the less likely it is that she's still alive. Of course, I mean, there are many moving pieces. There are multiple agencies involved. And so I mean, it's hard to say. And law enforcement hasn't been super forthcoming, understandable, but, um, they had, uh, I don't know, earlier this week, maybe, or late last week, they had prosecutors out there going through the house. What does that mean? Prosecutors usually don't get involved until there's actually a suspect. So what does that mean? Um, I mean, it's just really hard to say. Um, it just doesn't seem like a case for ransom. I think the ransom letters, the TMZ ransom letters, and those sort of things, I think they were a smokescreen. It simply doesn't feel like a kidnap for ransom. Kidnap for ransoms aren't that common. So then the question is, what is the motive? Was it to get even with Savannah Guthrie for something she did? Was it somebody who's a crazed fan or doesn't like Savannah Guthrie? I don't know. Or is it something more nefarious and close to home? I mean, it's a it's just impossible to say at this point. I think we'll know eventually, but I don't think this is a case that's getting solved anytime soon. I wouldn't be surprised if this case goes a year before we hear something. There's just too many weird things, and it is a heartbreaking case. Anybody who has a elderly parent, I mean, is gonna see this as, we all get to the point where we just have diminished ability, physical ability to get around, to fend off, um, to fend off ne'er-do-wells, to physically react, let alone, she was medically fragile. So, I mean, you hope, um, but you can't discount that she was in frail health to begin with. And of course, the longer it goes on, the less likely it is that she survived. So, um, I mean, I feel for that family, but there are families all over our country who never get answers. You think about the victims in the Long Island serial killer case. One of the reasons that they found the first bodies was because the families of a woman were insisting that the last time she was seen was at a house, not Rex Heuermann's house, but at a house, out on the spit or whatever it is, and, that she had left the house because she was afraid. And that was a case where I don't think they've linked her to Rex Heuermann, and law enforcement really feel that she ran out into the night and, ended up probably dying of exposure, being lost there in the marshes around the ocean, and, that she may have had hypothermia and died of exposure. Didn't make I guess what I'm saying is those families were asking for answers to cases that happened 10, 15, 20 years ago. So, there are families all over the country who are still waiting for answers about their loved ones. We see this one because it's very high profile and because Savannah Guthrie is a public figure. But there are families all over the country in that same position, that may not ever get answers. So, it's good to keep them in your thoughts too. Well, we've hit the 2-hour mark, so I would love to remind you all, please like and subscribe. Please, if you have questions that we didn't get to tonight, drop them in the comments or drop me an email. Do look for our first Patreon episode of the Granny Files, and do look for an announcement about links to our Substack, which will be an archive of our newsletters and where we will continue to post new newsletters as they come out. I did want to say that I have a couple of questions for newsletters. One being, why is it so hard for someone who is factually innocent to get their case overturned on appeal? That one is the next for my newsletter. And the other question had to do with explain sovereignty and explain sovereign citizens. So I am in the middle of working on that one right now. So look for that newsletter soon. And I will follow it up with a newsletter about appeals and actual innocence. If you have ideas for deep dives or questions that you would like me to go deep on in a legal way, where we're talking about um, how the legal process works, let me know either by email or drop it in the comments. As always, I want to say thank you to all of you for being here. Oh, that's very sweet of you, Lisa. We don't ask for super stickers, but we always appreciate them when they come. So bless your heart. Thank you. Um, as always, I want to remind you to like and subscribe. That's what you can do to help our channel grow. And I also please say thank you to Jen. She is the best moderator in the world. I couldn't do it without her. So thanks again. And I'm going to say goodnight to all of you and hope that we have many more chats. I will see you next week for more True Crime Wednesday. I hope you have a great week, and I'm going to say goodnight.